action should not be taken against you under section so and so, so and so. If you don't file accounts 220, annual return 159 and section number. So, why action should not be taken? I don't know how this language they have chosen, very favorable language to them. Why action should not be taken? That's what I told you. The onus of proving lies with us. Why action should not be taken against you? Because these are the positions are violated. Then we have to say, no, I have to give 10 list. No, I have done properly only, and this went wrong, or this, whether wrong or right, we have to give all that. Still he is not convinced. Then it escalated in the form of inspection under section 209. The regulators will come and sit in the office of the corporate affairs company, and they will see the complete books of accounts. In fact, the more power is given, they are authorized to inspect the book and paper, not even books of accounts. Book and paper, again an inclusive definition. Everything under the sky is included in that. So they can ask anything. So once they found some information which is not coinciding, in fact the language you have to see. Under section 234, when the ROC, when the Registrar of Companies are inspecting officers, if we feel unsatisfactory state of affairs exists in the company, then he can take action. First of all, I don't really understand what is the question of satisfactory. What is satisfactory state of affairs? It should be some provision is violated, for I can understand your provision is violated. Something needs to be followed. The parameter is prescribed, that is breached. It's not followed. Yeah, you violated, then I am supposed to take action against you. What is the point of languaging when the Registrar of Companies or regulator or inspecting officer, whoever is nominated by the government, when he feels there exists unsatisfactory state of affairs in the company, then issue notice. Then I can issue with due respect to regulators. If I have a mindset, okay, I feel something is wrong, okay, issue notice. So then it escalates into the investigation. Inspection, then investigation. In that point of investigation, now the Serious Fraud Investigation Office, which is already functioning, will be involved. The Serious Fraud Investigation Office is already formed by virtue of the circular issued by the central government. As an agency, as an external agency, they are involved now. They will be involved, they will prepare an investigation report and they will hand over to the ministry and they will walk off. This is the role given to the Serious Fraud Investigation Office till now. That means under the old act. Now the same Serious Fraud Investigation Office, which under the old act is an outside agency, now it becomes enforcement agency. How? It is going to be the authority, enforcement authority, part of the provisions of the Companies Act 2013. Fine, what makes difference? Let it be, let they become, what going to happen to us? It's going to happen to us. Under old act, somebody comes and inspect the records. They found something, as I told you earlier. They have to prepare the report and they have to hand over to the ministry. Then ministry will see and they will tick, okay, class, there is a list is there, A, B, offence category is there, A, B, C, D, that they are following. Based on that, they will authorize whether regional director to take action or ROC take action, but central government itself to take action. There is a class is maintained by the government for their sake. So accordingly, they will take action. It will take a time and magistrate court, summon and timing, all this will happen. That's the way the process is going on as of now under the present old Companies Act 1956. That the future how is going to be under new act. New act, once the Serious Fraud Investigation Office, once they step in, all other authorities, all investigating agency, whoever it is, whether it is the Income Tax Act, whether it is any authority in India should step out. Then see the powers given to the SFIO. It's not that something SFIO we are thinking, okay fine, serious fraud only, it is going to affect only MD managing director. No, this is agent, not agency, no longer it's agency. This is an authority, enforcement authority under new act going to inspect a whole account, verify whole accounts, and what they will do, they will not prepare the report and all. They will immediately arrest and take the person. That is the power given to the SFIO. See, the power given to the SFIO, I don't think any other agency would have given the power in India. You can see the provision of section 211. For paucity of time, I can't show the provision. In fact, I wanted to show old Companies Act, new act, and what is the difference, what is the implication, all that. Already I am breaching the time. Not breaching the time. The serious fraud investigation, the provision is prescribed that once a serious fraud investigation step in the office, whoever the authority, irrespective of that level, they have to step out. And not only step out, they have to hand over all the files to the SFIO. See, the level the authority is given a power under Companies Act. Once they step out, they will see the record. If they found something is violated, they will take us to the. They have every power. In fact, I should rather say, serious fraud investigation authority is given a power of police authorities. In fact, the procedure followed under Criminal Procedure Code is when a criminal is arrested within 24 hours, he has to produce before the court. He should be allowed to consult his lawyer relative and should tell the reason. All this is now prescribed in the Companies Act itself. That's why I told you. However, the Criminal Procedure Code not. Whatever coming in the Criminal Procedure Code, the schedule. If you see the schedule 1 of the Criminal Procedure Code, there the offences is prescribed. What are the offences? Imprisonment for 6 months, imprisonment for 1 year, 3 years, 10 years is very minimum. Hardly we can see 4 or 5 items is coming in such a big list of Schedule 1 under the Criminal Procedure Code. It runs into 10 pages. Criminal Procedure Code, Schedule 1. What is the Schedule 1? That only prescribe whether offence is bailable or non-bailable. That only prescribe offence is cognizable or non-cognizable. What we are discussing is the section 448 and fraud is non-cognizable. Please understand. What is the implication of cognizable? What is the implication of cognizable? Cognizable offence, the person who is doing that can be arrested without warrant. Then non-bailable. So, in turn, in nutshell, what I am trying to say, anything we do, I am trying to linking that only here. Anything, any person does any act, or any other person also does any act under Companies Act, I will bring you in 447. See that you will be subjected to 448. Thereby you are losing the limitation period. I will be putting behind the bar, and you can't get the bail. But it's not that bail cannot be given under the Criminal Procedure Code. There are the prescription is provided where the public prosecutor should be given opportunity to not appear. You give. I'll take another 5-10 minutes maximum. So this is going to be the scenario where once the Companies Act 2013, we can't cool in a AC room, feel comfort ourselves and saying whatever comes, okay fine, talking to secretary or somebody outside, supplier, and saying that okay, signing alone we are doing. See the implication, this 448, everything should come. 448, 468 of Criminal Procedure Code and non-bailable, all this should come in the mind while signing anything. Because any document, I am not exaggerating anything here. Because it says any document, any return, any statement that is subjected to 47, 448, then 460 of Criminal Procedure Code. You are falling under the first schedule of the Criminal Procedure Code. Offence under IPC. So this is a position, not that I am exaggerating. So many authorities are given to SFIO. The important this thing I told you, that is the more important this thing, that it has got enormous power and humongous responsibility and authority is given to the SFIO than any other agency, not agency or authority in India. Of course, National Company Law Board, morning Mr. Arvind Panin has given a little information on that. These are the information which I want to share. Since I have been rather requested, they are warned better to close. We will have a floor discussion, and end of the day also we are I think having in a panel discussion. Probably any doubt you can put through that time also. I will be happy to answer. I'll close with this. Thank you very much.
Dhanapal, you have not spoiled the sleep of many persons post lunch. Probably many of them will be spending sleepless nights from here, who are going to sign balance sheets here afterwards, maybe spending sleepless nights. Bernard Shaw had remarked that his English is best spoken outside England. Probably he would know, if he had been here, he would say English is best drafted in Indian laws. I don't know, I don't understand how lawmakers, probably they take the definition or meaning from Wikipedia or Google to include all meanings, all commas in any definition. And I'm not going to be, we are not going to be surprised from this year in many of the public sector balance sheets. We have a host of signatures. Many of them will now refrain from signing. There will be only 1 or 2 signatures of only the important directors. Now, bar to taking cognizance after lapse of limitation period.
Chairman, it's not that signing alone. The fraud definition includes omission also.
Yeah, omission to sign also. Then.
If you don't sign,
so if somebody omits to sign also, they will be gone. So we may have to include these following persons who omitted to sign. So if officer dies, maybe probably his son or his daughter will also be questioned now, because law of limitation does not apply now. And another factor is the CSR. Now government can include one more item in CSR. The amounts spent on bailing out of charged directors, officers, auditors, consultants, these can also form part of the CSR activity of the company.
Again, I'm just interpreting. CSR should be made as PSR, professional social responsibility.
See, these powers of SFIO is going to be enormous. I don't know whether it will go into mushroom into different, like police stations K7, E7. This will also come, and this is not in our jurisdiction, sir. You will have to take it to that police station. That is SFIO. That is going to be the order of the day here afterwards, because it has got enormous powers. I am repeatedly telling, either the chartered accountants members and elected members or the company secretaries have not made any representation with regard to these powers. Only cost accountants who were deprived of certain assignments on these new companies Act, they made dharna in the capital. But chartered accountants and the company secretaries have not made any big debate or articulate to the Ministry of Company Affairs. This is going to be a very big SFIO. Maybe like Veerappan's special investigation team, this is going to be a very talk of the day in SFIO in the coming years. And I don't know whether these 10 years, 5 years, 3 years, maybe many of you would have doubts how many years it will be for you. It will be open to the floor. You can ask DHANAPAL, how many years are for me? You can ask her. He will be able to answer. Yeah.
Sir, we have to discuss, deliberate. It's not that something asking. We have to deliberate that who is prepared for what.
Huh? Exactly, sir. So with this, I think it is open to the floor now. Please ask questions now to Mr. DHANAPAL, because Gopalakrishna Raju has restricted him. Now at least he can continue on the question hours.
Please ask questions and get more scared. Okay, I am ready to.
Now over to Dhanapal for answers. Yeah, first the Subbarao will. That is only to prime.
Yes, sir. Sir, we are taking regularly the opinion reports from the professionals. Is there any penal provision against the opinion giving professionals?
No, the section I was explaining, section 448, it starts with the any written. Okay, and that too, it's not restricting to profession also. It says any person only it says. So anything signed, that's the reason I explained. The section